Alright, welcome back. In this video, we're going to talk about balancing minority rights and majority rights. Let's check it out. So, throughout American history, there have at times been pieces of legislation that have protected minority rights, and at other times have focused more on the majority and limited minority rights. Same thing with Supreme Court cases, so we're going to go through a brief history of that right now in this video. So if we start with Plessy versus Ferguson, 1896, usually thought of as one of the worst decisions in Supreme Court history, and this upheld the principle of separate but equal segregation. It said that as long as there was access to something else, like a school for black children as white children, they could be separate as long as they were equal. Now we know that in practice these things were definitely separate, but they were never even close to equal. But this led to a generation of Jim Crow laws. These were state laws based on that separate but equal principle that allowed for legalized segregation throughout many states that chose to impose these sorts of laws. Now, when it comes to Plessy versus Ferguson, if we fast forward to 1954, we get to Brown versus Board of Education, which we've already spoken about, but what it did directly was it overturned Plessy versus Ferguson. So whereas Plessy limited minority rights, Brown versus Board extended minority rights. It said that separate but equal was inherently unequal. So it was unconstitutional, and that led to, over the next decades or so, the next decade, 15, 20 years, we see a reduction in Jim Crow laws. Finally, the Civil Rights Act in 1964, again, stating that that sort of thing cannot happen anymore. So we see from Plessy allowing Jim Crow laws, to Brown versus Board, and then finally the Civil Rights Act getting rid of those sorts of things. If we come to even more modern history, 1993 Supreme Court case of Shaw versus Reno. This is one that we've spoken about already. It was one of your required cases back from Unit 2 about gerrymandering and redistricting. If you recall, the state of North Carolina, they drew a district intentionally drawn to increase minority representation in Congress. And the Supreme Court in that case said that the state could not do that. It couldn't racially gerrymander a district. Race can be a factor when drawing districts, but it cannot be the only factor when drawing a district. So this limited minority rights in that the goal of that district was to increase minority representation, but here the Supreme Court chose to focus on the rights of the majority instead of those of the minority. So this leads to the question, is the Constitution colorblind? That means, does it try to ban all racial distinctions regardless of their intention? Or is the Equal Protection Clause only trying to ban distinctions that harm minorities? Stick with me for the next video about affirmative action, and we'll talk about that very question. I'll see you then, but until next time, this has been a LaMoney production. Thanks again for watching this video. I appreciate it. Hit that like button for me if this helped you. I really appreciate that. Subscribe if you haven't already. See you guys in the next and final video of Unit 3.